Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the last week or so. And as is the norm, there is always a plethora of issues for discussion in any given week in Guyana. This week is no different. I want to commence by welcoming all of our viewers who are joining us on television from Region 5 West Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are joining us from Region 6 along the east bank of the Berbice River, New Amsterdam, and along the Quarantine Coast, welcome to another program of Issues in the News. And to our listeners and viewers who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live across Guyana, the Caribbean, North America, Europe, and further afield, welcome to another program of Issues in the News. Please press that share button on your phone so that as many of your friends and followers can join us in tonight's discussion. Press that share button on your phone or on your computer or on your iPad or whatever instrument you're using so that we have the widest possible audience. I see many of you have joined us tonight already. Nishad Sharma from Canada, Josh Singh, Rajiv Rajpat, K. Watson, Krishna Baldev, Sunil, and so many of you, thank you very much for joining us, and please make sure that you put your comments in the comment section, and you can ask me questions as well so that we can have an interactive conversation as far as possible. Lynette Mahabal, Mike Bikam, Tolara Moloridar, Dewanan Alfred, Zell Roma, and so many of you, good evening. And remember to pose your questions to me, pose your comments in the comment section so that you can become actively part of tonight's program and the discourse that will ensue. So I want to begin by addressing the strike situation. As you are all aware, the Guyana Teachers Union continue to strike. The government's position is that that strike is unlawful. I have been following this strike from the beginning, obviously with a view of examining the legal implications arising therefrom. And I have pronounced from the inception that the strike is illegal and it is politically inspired and driven. And nothing that I have seen subsequently have caused me to question my conclusion. It would be recalled that the Ministry of Education was engaging with the Guyana Teachers Union as of a few days before the strike was called. And as far as I am informed, the 60% or more of the union's requests were already addressed and granted by the Ministry of Education. And the remainder were being considered by the ministry, and there were ongoing engagements. There is also a terms of engagement in writing between the Guyana Teachers Union and the Ministry of Education. And as far as I am aware, the Ministry of Education, inclusive of the Chief Labor Officer from the Ministry of Labor, were complying with the terms of engagement. The ministry asked for some time to consider the remainder of the requests from the union. And while those requests were being considered, the union unilaterally called a strike in breach of the terms of engagement. That is not only unlawful, but is an expression of bad faith. And when one sees who is the main architect in the strike action, it is Ms. Coretta MacDonald, a politician and a sitting member of the National Assembly on the opposition benches. And when one listens to the rhetoric, it is clear, in my view, and it should be in the view of any objective observer, that political sentiments were the predominant driving force and are the predominant driving force in relation to the strike. I have seen now that Lincoln Lewis from the Trade Union Council has joined the fray. Again, another political character masquerading as a union leader. Lincoln Lewis has a firm and consistent record of being anti-PPP, anti-government, and he has now joined the fray. And the sentiments that he is expressing again are grounded in politics more than the interest of the workers. And that is what we have been saying from the inception. But some significant disclosures have been made as a result of the strike action. Trade unions are an important organ in the democratic architecture of any country. Guyana is no different. We have laws that provide for how trade union must operate, how they must be registered, and how they must account for monies that they receive from their membership. The Guyana Teachers Union, based upon the public record, both at the Deeds and Commercial Registry Authority and the Auditor General Chambers, have been abysmally negligent and delinquent in the discharge of its statutory duties and obligations. Section 35 of the Trade Unions Act of Guyana, Chapter 9803, mandates that all registered unions must file their annual returns, and it is called annual returns because it is required to be filed annually with the Deeds and Commercial Registries, or more particularly, the Registrar of Trade Unions, so that the public, the membership of the union, and importantly, the authority that regulates these bodies, one of which is the Deeds and Commercial Registry, must have a record of the intromissions and dealings of the union, in particular as it relates to its financial affairs. When the records of the Deeds and Commercial Registry Authority was consulted, it was revealed that since 2004, since 2005, no annual returns were filed by the teachers' union. The last annual returns filed was for the year ending 31st of December 2004. That is completely unacceptable. Nearly $2 billion have been received by the union from its membership, and there is no accountability whatsoever in respect of how these monies have been spent, for what purpose, and how much money is in the coffers of the union. Nobody knows. And transparency and accountability are not concepts that apply only to government. It applies to all public and private organizations, in particular public organizations or public authorities, of which trade unions are a part. On what basis you are receiving billions of dollars from your membership and you don't feel that you have a duty to account to that membership in respect of the dues that you levy against them monthly out of their income. At the Auditor General Office, the position is worse. No audited statements were done since 1989. In 1989, I was a student at Queen's College. Since the days of when I was a student at Queen's College, this union did not have its statements and financial documents audited as is required by the law. These are not ordinary abuse of power and breaches of the law and of the canons of accountability and transparency. So this union has no moral authority or legal authority, for that matter, to demand any type of standards from anyone, inclusive of the government. But as I said, the government, and in particular, the relevant agency, the Ministry of Education, has dealt reasonably with this union in accordance with good industrial relations and practices and procedures, and in compliance with the written terms of engagement that govern the relations between the two entities. So the government responded by terminating a service that the Ministry of Education was offering to the union. And that service was to deduct union dues from source and remitting them to the unions, to the union accounts. Deducting union dues from teacher salary, from the source, and transmitting them to the account of the union. Why should the government continue to offer such a service to a union that wants to hold the government at ransom and has unilaterally decided to call a strike while the government is negotiating and engaging the union in good faith? Why should a government aid and abet the misuse and abuse of union dues on behalf of the teachers of this country? Why should a government continue to aid and abet a union that is violating all the principles relating to responsible administration and good and transparent management of the finances of the union itself and by extension its membership? So the government decided to sever that relationship, and the government was guided by a decision of our courts, both the High Court in the form of Chief Justice Chang and the Court of Appeal made a ruling that it is not wrong, it is not unlawful for the government to refuse to offer this agency arrangement of deducting union dues from workers employed in the government services and transmitting those deductions to different unions. The Public Service Union in that case had challenged the decision of the Permanent Secretary, Nanda Gopal at the time, of the Public Service Ministry, who decided to withdraw that agency service that the government was offering to the Public Service Union. And the Public Service Union challenged the decision of Gopal in the courts. In 2010, Chief Justice Chang ruled against the union, and that matter was appealed, and in 2022, the Court of Appeal of Guyana upheld the decision of Chief Justice Chang, and the union did not appeal to the Caribbean Court of Justice, as they could have, were they of the view that the Court of Appeal was wrong. So I see that the unions are now saying, through the president of the teachers union as well as Mr. Lincoln Lewis, that they will take the government to court on two grounds. One, that the government has, well, three grounds. One, that the government has severed the agency relationship. Secondly, that the government has made a decision to deduct salaries from the striking workers. And thirdly, that the government is refusing to engage in collective bargaining. Well, I've already addressed the first ground, the agency fee. That has already been settled. The agency service, rather, has already been settled by our courts and declared to be lawful. The severance of that relationship, that is. Secondly, they are challenging the decision of the government to deduct wages. Well, in my humble opinion, the government, like every other employer, has a right to levy a deduction against workers who are absent from work without permission, leave, or authorization. That is standard industrial law, standard labor law, and standard industrial practice. Persons are confusing the right to strike with a freedom to strike. The Constitution of Guyana, Article 137, confers upon every worker a freedom to strike, not a right to strike. And there is a huge distinction legally between the two concepts. Even a right to strike, like every other right, has responsibilities and conditionalities attached to it. You have a right to free speech, but you cannot libel me. You have a right to freedom of movement, but you cannot drive down a one-way street. Similarly, you have a right to strike, but it doesn't mean that conditionalities are not attached, or they are not obligations that are not attached to that right. When you deal with a freedom, it's a different kettle of fish altogether, because a right is still stronger jurisprudentially than a freedom. A freedom is the liberty to do something. And every liberty and every freedom has with it obligations and consequences. And if you decide to exercise that freedom, then you have to bear the responsibility or responsibilities and bear the conditionalities and burdens that go with that freedom. And one of the conditionalities and one of the burdens that the freedom to strike attracts is the right of the employer to deduct wages from the worker who has decided to strike and who is absenting from work without authorization, leave, or permission. One must remember that the contract that underpins an employer-employee relationship is a contract for services. And once those services are not provided, the employer who is paying for those services has a right to withhold his remuneration if you have decided as the worker to withhold your service. That is how the law of contract operates. That is how a contract of service operates. And most significantly, the withholding of your service, the withholding of your labor, constitutes what is in law called a repudiatory breach of the contract, entitling the employer to terminate the contract if he wishes. But in employment law and in employment relationships, that extreme measure is not normally resorted to by the employer, though he can lawfully employ it or resort to it. The resort which is normally activated by the employer is to deduct wages. And that is the law of Guyana, and that is the law of the British Commonwealth. Imagine if workers could have struck at will 365 days of the year, and an employer is enjoined or obliged to pay because they are striking and they have a freedom to strike. Then what will happen in employer-employee relationships? It will collapse because workers will simply say that they are striking and don't turn up for work 365 days of the year, and the employer will have to pay them. Just think about it. How can that be the law of any civilized country? It is not. The law is very clear. You withhold your labor, the employer can withhold his pay. And that is the law of the civilized world. So if the government decides to withhold pay, then the government is perfectly within its rights, lawfully, to do so. And on the third point that I understand the challenge is going to be launched on, collective bargaining, well, you have to come back to the government. Our government doesn't want antagonistic relationship with workers. We are a working class government. We don't want acrimonious relationships with unions. We want to work with the unions. But we are not going to do so in bad faith. We are not going to do so under duress. We are not going to do so under any form of undue influence. We want to bargain fairly. And that is what the law provides for. And we are not in any way resiling from that legal obligation to bargain collectively with any group of workers in the country. But there must be protocols and established industrial terms of engagement. And the teachers have unilaterally, unfortunately, decided that they are not going to engage in accordance with those established protocols. So any action filed by the union or unions will be defended by the government. As I said, it's not the business of the government or the intent of the government to engage in court battles, either with the union or with anyone else. But as part of our duty to govern and administer the affairs of this country responsibly, we have to ensure that players, other sectors in the country, discharge their obligations too. We have to ensure that they comply with the laws too. Now, for the non-filing of these annual returns, criminal offenses have been committed, dating back some 20 years. Now, if we were really vindictive, or if we wanted to go after the union, we could have passed the file over to the police and said, look, investigate. These are criminal offenses that have been committed. I'm not saying that the government will close the option. I'm saying that it's an option that is there. It just goes to show you that we wish to move the developmental agenda of this country with speed so that we can deliver to the people of our country a better life. That is our priority. The teachers are jeopardizing the welfare of our students. They are jeopardizing the public good. And government can't stand idly by and allow this state of affairs to continue. The most important asset in our country is our children. The most important commodity that we can impart to our children is their education. These teachers are jeopardizing those fundamental imperatives, and we don't take that very lightly as a government. We cannot. So those are my views on the ongoing strike action. I want to move on now to Constitutional Reform Commission. As I have said last week to the press, almost all the nominations from the various stakeholder organizations have been received. As I speak, there is just one organization whose nominee is outstanding, and that organization has requested an extension of time, contending that they are still in the process of consulting to find a nominee, and an extension of time has been granted, and I am informed that tomorrow that nominee will be received. I am not going to disclose which organization it is, neither I am going to disclose the nominees from the various organizations. The President will do that at the appropriate time, as this is a presidential function. But the nominees of the People's Progressive Party and the nominees of the joint opposition in the Parliament have already been disclosed in the press. So the PPP nominees are yours truly, the Honorable Gail Teixeira, the Honorable Dr. Frank Anthony, the Honorable Pauline Sukai, and the Honorable Kwame McCoy. From the opposition, the nominees are from the Partnership for National Unity and Alliance for Change, Mr. Vincent Alexander, Mr. Sherwood Lowe, the Honorable Ganesh Mahipal, and Mr. Nigel Hughes. From the smaller parties being represented in the National Assembly, the nominee is Mr. Timothy Jonas, Senior Counsel. So these are the nominees from the political component based upon the provisions of the Constitutional Reform Act. You would recall that we promised that 50% of the commission will come from the political landscape, and the other 50% will come from civil society. Well, I've just disclosed, as it is already revealed in the public domain, what the nominees are from the political landscape. And these nominations tell you, in my respectful view, or reminds you once again, that the People's Progressive Party Civic is the only national party in this country. And the nominees of the Constitutional Reform Commission, in my view, indicates that. We have ethnic mix. So we have two Indo-Guyanese, we have an Afro-Guyanese, we have an Amerindian, and we have a Portuguese. We have two women and three men. Let's look at the other political nominees. APNU, Alliance for Change, you have all men. In fact, and the other party, the third party, all men. Not a woman representation. No woman representation here. Then look at the ethnic mix. You have from the joint opposition in the parliament, you have 1 Indo-Guyanese, and you have 4 Afro-Guyanese from APNU, AFC, and then Timothy Jonas, well, he's mixed. But look at the main opposition. No gender and no ethnic balance. I just thought that I would put that out there for your consumption. So I see that you are commenting. Thank you very much. I continue to look at what you're saying. If you want me to discuss any particular issue, please post it in the comment section. I will look at it and respond accordingly. And as I said, continue to press the share button on the television, on the computer, on your phone, on your iPad, so that we can continue to have the widest possible audience. So, as you would have seen in the press, APNU AFC has launched another political legal proceedings. Christopher Jones has filed an action against the Attorney General, the Speaker of the National Assembly, and Vice President 𝘠𝘕𝘠𝘠𝘠𝘠, in which they are seeking to have Mr. 𝘠𝘠𝘠𝘠𝘠 vacate his seat in the National Assembly due, according to them, to his unexcused absence. I will not get into the merit of the case, but I just want to point out a couple of things. So this is another frivolous, unmeritorious, and vexatious action filed by the opposition, and hopefully will be regarded as such by the court after hearing all the submissions. This action was intended, obviously, to score political points, and is another fishing expedition by the opposition, hoping that it will yield some catch. Every political action they have filed, not since 2020, but I think since 2015, and even before, have failed in the court system. Every single one of them. This is the latest addition to a long list. This constitutes another attempt by APNU AFC to pit one arm of government against the other. Here again, not learning from previous rulings, they are inviting the court to inquire into the business of Parliament. Significantly, I want you to focus on the basis of this challenge. Absence from the National Assembly. Now, I am of the view that there is no other grouping of members of parliament in the democratic world who are absent more frequently from the National Assembly than this grouping constituting the opposition in Guyana's parliament. And I'm asking any reporter or person who is interested in the research to conduct an inquiry across the globe and tell me which other parliament has a greater number of members absent in the world than this group in the opposition. You who are listening to me must have seen on the numerous occasions that you are viewing the live sitting of the parliament, how many seats on the opposition benches are empty. Are empty. They come either at the beginning of the sitting, they eat, and then they disappear. Or they come at the time when there is food, they eat, they spend a few minutes in the parliament, and they disappear. And there are many of them, one of them in particular, who also was not in the parliament for the entire budget season. He was out of the country for that matter. More on that later. But you know, there is a saying that when you have glass house, when you have a glass house, you must not throw stone. And these people are guilty of that on almost every occasion, on any front. So they would be the first to talk the loudest about the rule of law, about constitutionality, and about democracy. And you know of their track record, both in and out of government, of violating the Constitution, of trampling upon the rule of law, and of attempting to steal elections, and stealing elections in the past. Then they like to speak about conduct in Parliament. Conduct in Parliament. They want to be the behavioral barometer and the epitome of virtue and rectitude when it comes to behavior in the Parliament. And just remember the 29th of December, 2022, when they were whining and grinding and gyrating in the Parliament, singing and blowing whistles, and when they attempted to steal the mace, broke the mace, and ran away with it. And these are the people who would lecture you about propriety of conduct in the National Assembly. And if that was not worse, if that was not bad enough, they run to the court to sue the Speaker for suspending them. Here again, nobody is more absent than them. I could count on my fingers how many times Norton attends the Parliament. Or if he attends, he marks his name and then you don't see him back. And that applies to all of them. If they have to speak, they speak and then they disappear. You don't see them back. I don't understand the logic. I don't understand if they don't think, if they don't examine these things, that if they're going to challenge the absence of the other side, that it will bring attention to their own absence, which is so permeating and prevalent. But that's the opposition you have to deal with. And once again, they are demonstrating their morbid fear of 𝘔𝘁𝘵𝘠𝘭. They are demonstrating their morbid fear for this gentleman. So they want to get him out of the parliament. As I said, I'm not going to deal with the merits of the case, but I've expressed the view that it is frivolous, vexatious, without merit, and it is a fishing expedition. And it is filed by Roysdale Ford, and I believe that this is another attempt by Ford to aid his ailing ambition for leadership of the party. This is part of his campaign to bolster his credential for the contest of leadership. Well, he doesn't have a great track record in the court, in these matters in particular. And then again, he's the only senior counsel on their side, and they did not consider him qualified to sit on the Constitutional Reform Commission. So he must be smarting under that brutal insult. I would have been very insulted if I were in a political party and I'm the only senior counsel to sit on a commission like the Constitutional Reform Commission, which is a legal commission, and have been overlooked by my own party. That would not have been something that I would want to advertise, but they have to deal with that. I want to also welcome a ruling from the Chief Justice, recently delivered, whereby Her Honor found that Section 14 of the Matrimonial Causes Act, Chapter 4502, is discriminatory on the basis of sex and gender, insofar that it only allows a wife or a woman to secure maintenance. When the case was filed, the Attorney General was obviously the respondent, and very early in the proceedings, we conceded that the Act, the Matrimonial Causes Act in its current formulation, collides with Article 149 of the Constitution, which guarantees protection against discrimination on many grounds, including sex and gender. And we indicated to the court that we will amend the law to remove that discriminatory germ from the legislation. I am pleased to report that the amendment is already drafted and will soon be taken to the National Assembly for consideration. Another important announcement I wish to make is that Guyana is now a member of the Egmont Group, or the International Association of Financial Intelligence Units. This is a global organization of all the international association of all the financial units, financial intelligence units of the world. They number 174. We had an application pending for quite a while. The Caribbean Financial Action Task Force supported our application. Trinidad and I believe the British Virgin Islands sponsored or co-sponsored our application, and at the meeting of this organization held on the 1st of February in Malta, our application was successfully considered and granted. So Guyana is now a member of the Egmont Group, and this will allow Guyana access to an international platform for sharing of intelligence, investigative reports, and evidential matters in anti-money laundering and countering the financing of terrorism. This will put us up there with 174 different countries. So, again, Guyana is moving to important places across the globe. I have seen in the press as well a number of news articles where the certain important commercial organs in our country and business entities have been calling for a review of our securities market and our securities infrastructure. I am pleased to announce that the President has instructed a review of the relevant law, the Guyana Securities Councils Act, and to modernize it, to expand it, and to refashion it to meet an expanding, competitive, and modern commercial and financial environment developing in Guyana. Work has already begun, and the services of experts have been retained, and another expert, another person whose expertise is widely respected in the region is being pursued. So that is another important endeavor which we are engaged in, recently embarked upon, as another demonstration of our government's commitment to modernize the legislative landscape of our country. We are fastly approaching program time. I'm looking at your comments. I see one comment, the program is too short. Unfortunately, an hour is not a short period of time for one person to be speaking continuously. But I take that as a compliment. It means that the program is very interesting, and a lot of people are tuning in to the program. But as I said, I would really like your input and your discussions so that you become part of the program as well. Because once you become part of the program becomes even more interesting and more interactive. And that is what the intent is behind the program, so that we can have a conversation. It's not a monologue. I want us to have a discourse, and I want your views to be part of the narrative as well. I see, I should also announced that very shortly the magistrates who have recently been appointed by the Judicial Service Commission will be taking their oaths of office before the Honorable Prime Minister in accordance with the law, and it would be a very historic inauguration because I know that it is the largest batch of magistrates that will ever be appointed or will ever be sworn in at the same time. It's the largest batch of magistrates ever recruited in the history of our country. So again, we are making unprecedented development in every sphere of the country. I want to thank you very much for spending the past hour with me. I believe that we have covered some very important issues, and I want to invite you to join me next week as we resume our discourse to treat with a new and different set of issues, or the evolution of some of these issues. Until I see you next week, please stay safe, enjoy the rest of the week, but more immediately, enjoy the rest of tonight. Thank you and take care. I'll see you next week. Thank you.